Hello, I'm Deborah Scales. I'm an employment lawyer with Cartwright King solicitors, and I'm recording this on Tuesday, the 12th of May, in the week when the Prime Minister is encouraging people who can't work from home to go back to work. A lot of surveys suggest that some people are too scared to go back to work, and so what I want to look at briefly is what are an employee's rights if they are treated badly or dismissed because they refuse to go back to work because they believe it is unsafe. Yesterday, the government published guidance called Working During Coronavirus, and its aim is to help employers bring people back to work. And the guidance includes this sentence, which reads, "The government is clear that workers should not be forced into an unsafe workplace." Now, it's important to appreciate that there is no law against an employee working in a potentially unsafe environment. Think, for example, of the petrochemical industry, construction, aviation, transport, and so on. But those industries tend over the years to have developed a whole raft of specific health and safety legislation. They're also heavily unionised, so trade union health and safety reps are able to negotiate on the employee's behalf. Until coronavirus came along, nobody imagined that a shop, an office, or a restaurant could be a seriously hazardous place to work. This government guidance is statutory guidance, which means it needs to be followed, and if a dispute ever came to court, it would be taken into account. However, the law that applies in these cases was drafted some 25 years ago, and it can be found in sections 44 and section 100 of the Employment Rights Act 1996. Now, these two sections protect employees from a detriment, for example, having their pay cut or being bullied, or from dismissal in health and safety cases. I'm now going to paraphrase from key sections of this Act, and it should come up on your screen. Where employees reasonably believe there is serious and imminent danger, they may leave the workplace or refuse to go to the workplace or take appropriate steps to protect themselves or others. So let's start with that phrase, serious and imminent danger. If you've been watching media interviews over the past few days, you'll have heard trade union leaders say that workers don't need to go to work where there is a serious and imminent danger. But what if the employer said, it's okay, it's perfectly safe, we've followed all the government guidance and everything is sorted, hygiene, social distancing, and so on, you must come back to work. But the employee still refuses. They believe it's unsafe. It may alarm the businesses to know, but the employee's reasonable belief will trump the employer's opinion. So how do we decide what is a reasonable belief now? All of the cases under the Employment Rights Act 1996 were decided before a global deadly pandemic. We think one way is to look at the appropriate steps that the employee took. Are they disproportionate and unreasonable, or reasonable? I'm now going to pull up onto the screen the wording of the legislation itself, and again I've highlighted the key phrases I'm going to come back to. So here we go. It reads, whether the steps which an employee took or proposed to take were appropriate is to be judged by reference to all the circumstances, including, in particular, his knowledge and the facilities and advice available to him at the time. I'm now going to very briefly look at three possible different scenarios under this appropriate steps clause. The first one, in all the circumstances and taking advice. Let's suppose the employee is in the highly vulnerable category or lives with somebody in that category, and there's advice from the GP or Public Health England that they should not go out to work. Then in that case, they may be taking appropriate steps by refusing their employer's request to return to work. Remember also that employers have a duty under the Equality Act 2010 not to unlawfully discriminate against somebody because of their protected characteristics such as their age, sex, race, pregnancy and so on. So employers need to be mindful not to risk a discrimination claim on top of everything else. The second scenario looks at the knowledge that the employee has when he decides to take whatever steps he's going to take. This is why it is so important that the employer shares their risk assessment with the employee. If the employee doesn't know what steps are being taken to protect him, it would be perfectly reasonable to refuse to go to work. The government guidance goes even further, and it requires the employer to appoint an employee representative to consult on those appropriate steps. This third and final scenario looks at what steps somebody might take to protect themselves and others. Let's suppose we have a waiter, there's a queue outside, his boss insists that he lets the customers in and serves them. It means the customers can't be seated at a social distance. It puts both the waiter and other customers at risk. The waiter refuses to serve them and walks out himself. He may well have taken appropriate steps to protect himself and others from danger. If that waiter had also reported his boss to senior management or possibly some other authority because he believed that the health and safety of other people were at risk and he was dismissed and subject to a detriment, he would also have a whistleblowing claim under section 47B1 of the Employment Rights Act, but that is a subject for another day. So what are the consequences for the employer if they unlawfully dismiss or disadvantage an employee under these two sections of the Act? Well, firstly, a dismissed employee won't have to have 2 years' length of service to bring an unfair dismissal claim. It will be automatically unfair. It also means that any compensation for loss of earnings is going to be uncapped, and that can be very expensive in a time when new employment may be very difficult to find. If the employer subjects the employee to a detriment, such as cutting pay, then they will need to compensate for any losses flowing from that detriment. I hope you found this brief guide helpful. Thank you for your time. You can find more information on this and other areas of law on the Cartwright King website, Facebook page, YouTube channel, or follow us on Twitter and LinkedIn. I must give special thanks to Gus Baker, barrister at Outer Temple Chambers, for his excellent paper and seminar on this really difficult subject. I hope to come back to you one day very soon to tell you that we are no longer in serious and imminent danger because we've found a vaccine. But until then, stay safe.